Hi, good afternoon, everyone. I'm Karthikeya Singh, joined by Professor Dr. Heinz Godar and Dr. Matthias Hoffman. We'll try to delve a little deep into AI and autonomous inventions. We'll look into what AI is and whether AI can be used as a tool and whether AI is a tool or a inventor. And then we'll try to get a little bit deeper into whether it can attribute itself as an inventor. So my first question is to Matthias, is from a European perspective and specifically from Germany's perspective, AI tools are being used in the legal fraternity. And how do you think AI tool is changing the legal industry as a tool?
I think it's clear that the impact on the legal field is huge. Yeah, I mean, it's for us patent attorneys and attorneys in general. The advent of modern language models is, to be honest, overall bad news. Yeah? Something that traditionally only highly specialized attorneys could do, something that we trained for many years for, and that then was rewarded with high hourly rates, suddenly can be done by, in principle, be done by tools that cost $20 per month. Yeah? And what we see in Germany, I think the same as in other countries, was this initial enthusiasm. Yeah, there was initial absolute fascination with it. Then we saw after that a certain disappointment. Yeah, it's with every hype there is also a certain realization. Yeah, that it's not yet pure magic. Yeah. And because people realize that there can be hallucinations, for example. But what we now see is that people have learned how to use it. They understand what it can do and how it needs to be handled. Yeah, and how, for example, always the right context needs to be provided. Otherwise, it will hallucinate. Yeah, and a language model, if not given all the necessary information, it will not say, "Sorry, I can't answer that," but it may simply hallucinate. And people have learned that. And also, there are tools now which provide all the necessary context and grounding. And now it's making its way into daily practice in law firms. And I see that from both sides. Yeah, I have double roles as a partner and patent attorney at Böhmert & Böhmert, and as a founder of Patent Maker, as a tool provider.
So just to piggyback on that, how, from pre-drafting phase, which is the searching phase, to drafting phase, then prosecution, how does Germany and German legal firms use AI tool to, and how much of it is, as you said, hallucination, and how much of it is helping from prior art search perspective, from drafting perspective?
I think it has made its way into all of the areas that you mentioned. Yeah, from searching to drafting to prosecution to litigation support, and it's for searching. It depends on how you define AI. Yeah? If you refer to complex trained algorithms, then it has been around actually for quite some time already. For drafting, definitely. In drafting, the moment the most common use is fleshing out a structure, that was provided still by the attorney, and for that it's a very good tool, especially in European prosecution, where if we do any amendments later on, it's important to have unambiguous original disclosure in the description, which means it's very helpful to have a lot of disclosure, and very rarely would it be harmful that you have too much in there. And therefore, for example, for this task, it's ideally suited and just requires checking by the attorney. I think this is something, this is frustration, yeah, maybe to attorneys that that I mentioned in the beginning. They see that it's good, yeah, but they may, and that it gives, not only makes them more efficient, but also gives better results. But there may be a little bit of frustration that the attorney is kind of degraded to the role of reviewer of the work and checking large amounts of texts generated by language models. And we see it now also in like, of course, in prosecution, yeah, where it can easily check for any mistakes, yeah, that the examiner may have made, yeah, checking whether the reasoning is correct, pointing to the attorney out potential routes of arguing for establishing patentability, either by saying here the examiner is not correct or over-interpreting what is in the prior art, and the attorney then checks that and merely selects among provided options how to proceed.
Perfect. So just I'll direct this question to Heinz. As a German practitioner, how does it help from the enforcement aspect, from the litigation aspect? How, like, has AI influenced German practitioners anticipate examiner behavior?
Yeah. Sorry. Thank you so much. First of all, maybe if we start with the examiners and their behavior, yes. In the EPO, the career of an examiner depends largely on how many office actions you do per year and all these things. And we have very often the impression that what the examiners does is created by a button, and then comes a clarity objection, because that you can issue out with the help of AI without having understood the invention at all. And then we have the first point for this year of the 12 office actions which you should do per quarter in order to be promoted and get more money. But so this is a little bit sarcastic, but of course, we develop also, I mean, Matthias is for a number of years already is a partner of mine in Böhmer & Böhmer, which I have founded in 1972-73. So I'm a physicist. I was an assistant professor for polymer physics, and then I studied law, what normally patent attorneys don't do, and then I did what I do now here, for example, to work with capable young people who understand AI like Matthias. I think it has something, I see this in my personal field. I have a lot of demand, for example, for freedom to operate opinions, and the search is to find, first, prior art that could be, no, not prior art, patents that could be infringed by products of certain of my international, also domestic clients, that can be identified much better with the help of AI tools, whatever here, for example, Matthias and his team in my firm are creating. And it has also a different field still, or maybe similar. The next step is a search, how can I destroy these patents? Because the typical thing is 10 patents could be infringed. To do really, you think, oh my God, we have to do something. The most expensive thing is we have to construe around and to avoid that. So let's try to kill that patent. So search, please, worldwide, prior art, one button, every thing comes up. So I'm personally of the opinion that 90 to 95% of all patents worldwide are invalid. So they can be attacked. I am much better and more inclined to destroy patents personally than to enforce them, and because they would be valid. Interesting things, I do a lot of litigation, practically only that, but I'm usually on the side of companies from Greater China, companies from both parts of China. So Indian companies, German companies who are attacked by the big trolls of this world, and they say we have a standard essential patents. We have 1,020 standard essential patents. Out of them, I would say a little bit less than 10% are standard essential. The other 90% you can forget, you can throw, either not enabling because training data are not there for generative AI, patent is invalid, and all these things. And then AI helps a lot. And one of my role in the firm is, I mean, first of all, I manage the firm, but Secondly, it is to have people like Matthias, for example, who can then develop the necessary AI tools for this. Because then you need to have somebody, and this is at the moment the task on which he is working, how for little money, very quickly, you can, in the SAP portfolios, which comes from San Diego, Qualcomm, comes from Sweden, Ericsson, comes from Finland, Nokia, whatever. I don't wish to discriminate anybody here, but then you can already sort those so-called SEPs out, which you better forget, because they can be destroyed, and or they are not used, or not necessary at all to make your phone here in Bengaluru talking with a phone in San Diego or something like this. And that is, without AI, very difficult. And I'm eagerly looking forward. He knows every day, practically as my evening prayer or whatever, when I sit with him here on this journey for dinner, for example, that I say, when do we have a tool which my people in Shenzhen can use, for example, to identify the real SEPs, which then need special treatment. They need then to be subject to freedom to operate. You must put some currency at the side, how you can buy a license, because the big patent portfolio holders in this world don't wish to be paid in US dollars or in euro, at least mostly not. They wish to be paid in cross licenses. So what you do is you create a portfolio, and creating a portfolio is not legal cost. This is just to create a special currency, the only currency which big portfolio owners accept. They wish to have the freedom to operate themselves if they are partly at least producing or licensing companies like Qualcomm, where they wish simply to give their licensees, but they also make, of course, devices, components, whatever, to guarantee them, if you use that and that, we have already got the currency by cross-licensing to allow our licenses to use that license from Nokia, for example, who, as we know, don't make rubber shoes anymore, but they have, for good reasons, went into the phone business, the mobile phone business, which unfortunately another client of mine from Redmond bought. That was the biggest, I think, money-sinking acquisition which was done in the last 20 years, but that's a different story. So, I think AI is inevitably used by anybody who wishes to do something with licensing, cross-licensing, litigation, invalidation particularly. Without that, we couldn't do it. And the way Matthias went with his one hat, where he is a partner of mine, also, he's not a physicist only, he understands really AI. I know what AI, I like this thing here. I know what AI can do. How AI does this, I really don't know. Yeah, but very reliably. So he transformed in the firm, in my clientele, whatever, others also, transformed our analog procedures into digitalized procedures, to do things much faster, to do it much quicker, much more reliably, etc. And besides of that, also founded then a firm where I do not participate in, but we give advice to that firm, which is called Patent Maker, which has most, I would say in Germany at least, the most advanced drafting, office action handling, FTO, hopefully soon SEP handling AI instrument in the world. So I believe it is without AI, even for a very small firm, not possible to do freedom to operate and invalidation and patent litigation work. It's not anymore possible. That should not lead to the fact that not persons like Kevin, for example, sit there and give some advice to a client what he best should do. This is something we can direct things, but there must be somebody in that team. And if the firm works with another AI specialist, something like Patent Maker or whatever, which is used by many German IP firms in the meantime, like our instrument Genies you probably use. I was created with my intervention somewhere in the 95, 96, long time ago. But it's also our original ideas digitalized in a reasonable manner. I think without AI you are dead or will never come to life. And so, yes, very important. Thank you.
So, long and short of it is that AI is a double-edged sword, probably. For SCP, we have a lot of issues when it comes to over-declarations. A lot of companies are doing that. We
Yeah, just a comment. When I talk about over-declaration, I never forget to say that the people who do this don't do this in order to make other people angry or for nothing good purpose. We have case law in all important jurisdictions of this world. If you forget, whether intentionally or really forget, to declare something which you had in development in the standardization process already, then comes the ambush situation. And nobody wishes later on to hear in a court, oh, sorry, you knew this already at the time when you were sitting in this nice little Germany AG in Frankfurt to define a no phone standard. And United States, the same thing. IEEE is very nervous then. So this is why they over-declare. They do over-declare because there is nothing wrong in this, except that you have the risk, of course, that later on ugly people like me, for example, will destroy many of your patents. But that's a different story. But you should better over-declare than under-declare. Under-declare is life-threatening.
So just to add to that point, so when you're using AI as a tool for, say, for SCP standard essential patents, the flip side of that is the inventorship of it, the aspect of what would be a person skilled in the art, what would be obvious to an AI. So if you're using an AI tool and it comes up with a patent, an invention, so what would be considered as a ordinary person skilled in the art?
Can I say something on this? Okay. I have a lot to do with this question. I work closely in many conferences and also not conferences only, but in practical work with the chief judge, presiding judge of the Patent Senate of the German Supreme Court, who is Dr. Klaus Bacher. And he wrote personally the German Dabus decision 2 years ago and cleared things forever as far as Germany is concerned. And the model is used by Japan in mainland China. It is definitely decided in a convincing manner that only a human being can be the inventor. And there, AI is a tool. And you see this, for example, when you just come into a situation where somebody has this idea to use a generative AI, let's say, which makes new turbine blades out of flight data, temperature control along the turbine blade. You get totally new forms of the turbine blade. Who is the inventor of that? Well, we have learned in our early days, I think, well, you are much younger than me, of course, Kevin, but I have reached 86 anyway. But what I do with passion. And I can only say, when I learned to patent law, or tried to learn it, I learned it actually for a certain extent, otherwise I would not be a professor for intellectual property law. The only one in Germany who is not a lawyer. I'm just a patent attorney. So, patent agency, Americans would say. But then you come to the point where you would think, I could use this machine, which consists of a data collector, and an AI system and a computer and a three-dimensional design maker or something. That is the machine. And this did until today only make in the marketplace turbine blades. Very nice ones, possibly inventive ones. Nobody could foresee that structure here, and that machine is patentable, of course, because there is a human inventor in that machine. Now somebody comes, I have a similar problem with the brake discs of bicycles. I wish to have less material where there are lower temperatures, and I don't need so much material. It is better, not so abrasive and whatsoever. Let's try. I take this machine which they use until now, since 20 years, no, it didn't exist yet, since 1 year maybe. This is a fast developing area in which we are. He used that for turbine blades. I have a similar problem. Let's look what it does with my disc brakes in bicycles. And out come a new disc brake with less material here, wonderful miracle properties. Who is the inventor? The machine did it all, except to create the task. And what we have learned in 1970, 72, when I started to be interested in physics, later on then for patent law, was an invention consists of a problem to be solved and the solution of that problem. And here is, which is now, the combination makes up the total inventive idea. Now comes the first one. Here is our person interested in the disc brake, which for bicycles, which should be improved. And he has this idea, one could possibly use this system for creating new disc brakes. Then the one part is solved by that person, who is always, until today. Klaus Bacher from the Supreme Court in Germany says, maybe in 10 years, and I give you a scenario how that could be done then and look like. Today, it would always be a human being who sets some generative AI system onto a certain task. The task is then automatically solved more or less by the AI system with computer design extruder or whatsoever. And that is the inventor. He uses a tool. And that tool can be very sophisticated. Without that tool, he could not do anything. But to have this idea, setting it onto a new problem, that is then the sole inventor. And he uses a very sophisticated tool. Now we come to a different world. Let's say you have a machine, we just discussed it in the car actually, when we came here. You have let's say, some generative AI, what can do the following. When there is a number of human beings, it has been designed to put these human beings, divide them into certain quarters, certain compartments. There are the good people, there are the bad people, there are the semi-binary, I don't know what people, and it does this very reliably. And now you put this machine into front of a classroom, like us here, and the machine is not told what to do, sits here and all of a sudden starts to divide the people here in little squares where they all sit. Nobody gave that task. Who is then the inventor? And I said to Klaus Bacher, and he has not yet an answer for that. I said, the inventor is the one who put this machine in front of this room here. That is the inventor. So the last human being bringing the whole chain of solution, creation and solution, and also the solution for that into work. So it is always at the end of this whole crowd of people, or at the beginning, better to say, there is a human being. Everything else is a tool. And even if a wonderful mega painting piece in the style of Leonardo da Vinci and the machine does this, I could hardly make a little pencil drawing, something like that. But I created at least the turbine wheel in my own trademark of the firm Böhmert and Böhmert. I had this idea in '72. I thought, we are technical people. We all were scientists at that time, and we have also lawyers. So they should meet, maybe in the sense of what the firm does here. And what can we do? If you put paragraphs, we use in Germany for paragraph, article in American language, paragraph signs next to each other, clearly legal, paragraph 1 is 24 and whatsoever. And I said, wait a minute, we make a turbine out of it, which is now paragraphs, 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 you see it up there somewhere, and this is then legal and tech also. This is something that what I could do, but that is a maximum. I could not make a Leonardo da Vinci painting. But if you have a wonderful brush, if even a stupid person like me takes it, no, an artist, take it into my hands, and it starts in 5 colors in parallel to do something wonderful there, this is still a tool. This is not me. me, but I have set it onto that task to make this painting in the style of Leonardo da Vinci. That's all. Sorry, a very long answer to a very short question. Sorry.
So this one's to Matthias. So would you consider, because I know you have the technical background when it comes to machine learning, so would prompt engineering be considered as the inventive step in a case where you would have an idea and you put a prompt into an agentic AI and then that comes up with a solution? And how would this impact the sufficiency of disclosure of patent applications?
Do you say something? I need now to say one sentence. You need the data to train your self-learning systems, and this data protection is today's a big problem. They are trade secrets, and you need them to make the whole patent enabling, so 90% of all these patents of this kind are simply invalid because of lack of enablement, because the data are not.
So to your question, yeah, the question was, is the prompt writer then the inventor, or is it the yeah? I mean, there's no case law on that yet, but in my opinion, it's clear. Yeah, it's the prompt writer. Yeah, the one who comes up with the direction, and we see that already. I mean, at the moment, if someone is just phrasing the problem correctly, yeah, and guiding, for example, a professor at university is guiding a student into the direction of what to do, then later on both would be considered inventors, yeah. But definitely the one who is guiding that is an inventor. And at the moment, AI will generate many things and suggestions, but the one making a selection, and that's the human, I would consider as the actual inventor. Yeah, and the same like, well, we have the selection invention, where it's invention to select from a known list. Yeah.
So again, it's a procedural question to Matthias. Then, do you suggest clients or your clients to disclose as to how much of AI tool is being used to draft the patent application?
I don't see the advantage.
Sorry, in light of the Dabus case, like, because you need to disclose who's doing that, like, so.
The Dabus doesn't say that you have to disclose it. It says that you can name and indicate a contribution, but so far there is no, in German, no requirement. And to be honest, in my opinion, it would be ridiculous to have such a requirement, because AI, the term is so broad that it covers smart algorithms, anything that potentially has been trained. So anyone who already 5 years ago was writing a patent application would have, for example, spelling correction, yeah, or grammar detection or something, and arguably that's also AI, yeah, smart trained algorithms. So would I then need to write that the Microsoft sentence correction, yeah, was used in this? That doesn't make sense. So what met at the state that we're currently at, and this was also stated in the Dabus decision where we stand at the moment, it's the human who is guiding this, and that's why the human inventor must be indicated, and whether there were contributions by AI is secondary. You may mention it, but I also don't see the practical relevance of it, right? I mean, an inventor, a human inventor, who is named on a patent, then later on has rights because of that, right? I mean, the right to be named, the right for remuneration, yeah, for example, and these are all things that only make sense in the context of humans, yeah? And if at some point we are at the stage that the AI tells us that it wants its just reward for its contributions, I think at that time we will have a whole lot of other problems to worry about rather than who to name on a patent application.
At the moment, I can only say who really wishes to know whether AI was used are my clients, because they wish to reduce the billable hour rates, what they pay for it. Thank you.
So just a follow-up question to that is then, again to Matthias, is Germany, the German procedural aspect of patent application, has it changed post-Dabus? Is it is it, are you doing something else? Are you telling your clients to disclose AI as or?
No, in practice it has not changed yet, and I think both on the client side and on the attorney side, the trend is going to quickly going into that direction, that everyone is somehow, somewhere using AI to different degrees, and on the other side, nobody cares. Yeah, I mean, if you receive something where a little bit of an AI was involved to correct, for example, a mistake, then the recipient is grateful. Yeah, and on the other hand, if an attorney sends something out with mistakes in it, yeah, with citing non-existing case law or whatever, then that is bad, and the attorney is liable for it, no matter whether he used AI or not. Yeah, there were these famous cases where, of course, the public outrage maybe is larger, yeah, if it's obvious that they were using AI and blindly using it, but in the end, what matters, was it right or wrong? And if, for example, an attorney had given the task to an untrained junior associate, yeah, and had sent that out blindly, it would be the same effect. Yeah.
What I would like to recommend to the practitioners here who draft patent applications, however, to draft a claim that a certain product or a certain result was made and achieved respectively with the help of an AI system looking like this, because then we come into a new field of case law with certainty. We have the product by process claims, and we have the rule nearly all over the world that things which are made by a certain method, if they are new, they are also protected by the method claim. We don't have this for apparatus claim. For research tools for pharma, for example, I have since a long time tried to fight for this, but the right case didn't come into my hands, that if you formulate the claim correctly, namely made of a claim where an AI system for selecting, for example, from 10,000 compounds, 5 which could be pharmaceutically useful or so, then you should formulate a really method claim out of it. One step of the method consisting of that by an AI system having this and this features with certain subclaims is used. You select a certain compound out of the 10,000, you process this further into a state where it could be a pharmaceutical. We don't have case law on this. The EPO particularly was that unholy institution in the world which in the late 70s created this idea of research tools are patentable, but the products made by them cannot be protected by the same patent, which was a wrong decision under an opposition board of appeal under Mrs. Kinkeldey in the European Patent Office. I hope she is very safe. But this was wrong, and we must revisit this. Research tools, please put in as practitioners to help your client into the claim, make out of it one of the claims a product claim, which the result is then automatically protected also by this patent, and you go to court later on, there will be a very good chance to come to basic new decisions which say if an AI system was used, then what is being made by the AI system is also protected, like my brake for bicycles, what I talked about.
So this question is to both of you. Like, what would be the one takeaway from the Indian perspective that Indian patent professionals could take from DABUS, is from a policy standpoint of view or from a procedural standpoint of view?
In my impression, it would be nothing much changes so far.
Maybe come to what Kevin talked about. Maybe the professional tasks, the professional routines done by patent attorneys will change to a meta level. That means you will not anymore try to patent or to understand things what the machine can do, but the client will come, in which countries should I obtain which mixture of utility models and patents, where should I go, what should I prepare in defense already beforehand, in certain countries written protective memoranda to courts somewhere and whatsoever. This will be a higher level work for patent attorneys, which becomes more legal than in the past, where it was more or less transforming your third semester physics knowledge into some nice patent claim, how to make a smooth surface on a polyethylene crystal or something like this.
Thank you so much, Dr. Hines and Dr. Mathis. I think we're running short of time. We'll open the floor for questions.
I have a question about the break example. Being not a patent attorney, so I'm not in this field, but I can imagine that the prompts are very important in the future, because just one prompt could that lead to a patent? That's the question, I think. In the trademark or copyright discussion about AI, it's about how many prompts and how creative those prompts has to be protected by copyright, for instance. Do you foresee legal cases about what's in the prompt?
Yeah. So I had just recently spoken to copyright lawyers about this question. Yeah, because it's about protecting the prompt in Patent Maker. Yeah, so I was discussing that, and at the moment, like a simple prompt is not copyrightable, yeah, because typically it would represent something that, like for example, please write a background section or something. This would be a prompt, yeah, run in an AI tool, and this alone is not patentable. But it's as soon as, similar with other creations, yeah, as soon as there is a certain amount of creativity required and going into that prompt, then it would be copyrightable. And I think your question was a bit, but where does the copyright then come in? Yeah, is it for the initial prompt, which maybe was
about the patent example, because that's also related to patents, so because one prompt can lead to a patent. Yeah, I found that a little bit. I understand the example, so I follow the example, but I think the prompt has to have an innovative step, or that
yeah,
sort of
I mean,
thing?
but it could be that you enter that your prompt would be, dear AI, please write create an invention and write a patent application for a device for flying to the moon. Yeah, and then it would, with this one sentence prompt, which arguably is not creative or inventive at all, yeah, it would generate an invention and a complete patent application. And I'm with you. One could argue the only one who was here inventive, yeah, was the AI. Yeah, because the input was so trivial, just one sentence. But in my opinion, but that's just the individual one, it's still the human who makes the decision to file this patent as a patent application, right? So inevitably, the most the AI is generating so much text that the inventive step may lie simply in making the decision to file this as a patent application, because presumably everyone here has tried it already, AI, for getting some creative outputs, but you have not followed everything. You made the decision, yeah, what to follow and what to not, or in this case, where to write the patent application, and this would then be the inventive step merely in deciding this is worth filing as a patent application, and therefore I would argue it's still you who's the inventor, even if you only contributed a single sentence.
I did not fully grasp this question, maybe, but what we are working on in Germany, the legislator, that there is a modification of our copyright law, which makes it not only possible but necessary that creators of content which is used could be data, structured data, which are used as training material for certain AI systems, self-learning ones, that this is also a copyright infringement if you take without license the content of what you can read anywhere where it is be found by you. So Microsoft versus Washington Post, Microsoft would not have any chance in Germany. This is already now so. This is very clear that is stealing billions of protected materials. And we will have probably a special collective society in Germany, a new branch. We have one for music, we have one for text, we have one for videos. I don't know what, I'm not a copyright specialist. We have some in my firm, but there's a different story. But the collective society will then specifically be for training materials for creative AI. And this will be then explicitly mentioned that doing that you are conducting a copyright infringement unless you are member of a collective society which will come to you necessarily next day when you have done something like that and will write a nice letter, usually with an invoice, and you have to pay. That's it. Yeah, thank you.
I have a question about office action responses to patent patent prosecution. Does the tools that you're using, have we reached the point with AI tools where you can put in the patent application and put in the prior art, and then you will get a result that will a recommendation from the AI that the examiner was wrong and D1 does not cover claim 1, and here's why, and it gives you that, or it would say D1 is pretty much covered. Pretty much covers claim 1. So I think you need to go into the specification and find on page 12 this particular part and add that to the claim, claim 1. And here is the problem solved, and here is the solution according to the EPO problem solution approach. And option 1 that D1 is covering claim 1, exactly like the examiner says, and then you have to amend by finding something on page 12, and then add it to that claim. Or option 2, it's not covered. D1 does not cover, the examiner is wrong, and here's why. Have we reached the point where the patent attorney doesn't have to do this work anymore, and the AI does it?
Yes, definitely. Have a look at Patent Maker. Yeah, I'll be glad to demo exactly what you were referring to. It does that, yeah, and you don't even need to load the patent application or the prior art into that. It just does that already automatically. You merely need to indicate the application that you're prosecuting. And how we're doing it in Patent Maker is that it does a claim chart. Yeah, it analyzes it makes a feature segmentation. It analyzes for each feature what the examiner has said to this. Yeah. And then how it's implemented internally. It first makes its own opinion and then contrasts that with what the examiner said. So, and it will show then exactly how you say, yeah, that for example, here the examiner said that this feature is disclosed in paragraph 15. However, actually something else is meant there. What we see at the moment, and we highlight that in color, yeah, what we see at the moment is that AI, how I use it, yeah, in prosecution is it gives me suggestions. Yeah, for example, it would say that for claim 1, it considers that 3 features are not disclosed in D1. I still need to check that, and it may be that for 2 of them, I come to the conclusion actually it is disclosed. But even in that case, the third one will be right. Yeah, it has a good ground right, and then. It still saves me a lot of time because I merely needed to check the AI suggestions and then decide for what to proceed.
Okay, so you can treat it as if it were a young trainee that,
exactly.
that you say, please go and do, read the prior art, read the invention, come back to me. I will ask you questions. You then answer my questions. Then we'll decide. Because when I was very young, 24 years old, starting out in a law firm in Washington, D.C. I had this, you go into an intimidating room with, the Capitol in the background, on Pennsylvania Avenue, and the partner, this, experienced guy is asking you questions, and you have to explain very clearly what, to him. He's very impatient. You have to tell him exactly what's what. And, but you do all the work. The young guy does all the work, and the older guy is listening, asking very demanding questions, and then so you could treat it like this, right? You could treat this, but my question is it good? Do you think it's really, really good? Does it actually replace?
So who it replaces is exactly what you said, the young, inexperienced trainees or young associates, and AI continuously gets better. Yeah? At the moment, I would say a young associate who occasionally still makes a mistake. I called it in the past, as a young associate who really rarely comes to office drunk, and but this is actually this what we call hallucinations, is actually now has extremely gone down, and what we also see is hallucinations are often not because AI is not capable enough, but because it wasn't fed enough information to answer all the questions, and it's the time saving is already huge, and what we also see, who I feel sorry about for most, is indeed the young associates, because they are under competition with the AI. The senior people, not so much.
Okay. Thank you very much.
I like this question and also the discussion a lot, because if some of the young associates or so become so good all of a sudden and analyzes so perfectly, you should better have a closer look at what he is doing and where he is taking this thing from. Probably he is using a powerful instrument which he bought from somebody like patent maker, and you don't know. You think, oh, this is this young genius here I wish to let rise up in the firm. Anyway, this is, but no, technically, we have this unholy European, or it's good maybe, requirement that everything has to be originally disclosed. And to go through a 300 pages specification in the hope to find some half sentence which connects two elements or something, this is for human beings very troublesome. You need really to read. And this is for an AI. Where is it? Page 7000. There, something like this.
Okay. Wow. That's amazing.
So, to become independent. Depend on you as the moderator. Fantastic one, by the way. So.
Thank you so much, everyone, for being a lovely audience. I think we are,
Thank you so much. Mr. Karthikeya Singh, Dr. Gordar, and Dr. Hoffman. Thank you so much for navigating such a kind of fascinating and important subject, and so easily. Thank you so much. But please stay back. We still have a small act to play. We still have a kind of small gesture to make. I would request my colleagues, Shasti Deepa and Pooja, to please present the small mementos to the panelists. Thank you. And ladies and gentlemen, I am sure you will agree with me if I say that this kind of session essentially calls for a kind of big round of applause. Can we put our hands together, please? Thank you. Thank you so much. Thank you. Thank you, everyone. Thank you. Thank you.